everyone. Today afternoon, we have attorney Dhenu Maru. She is based in Chicago. SwagatUSA.com is her practice website. And she connected with me because her clients are part of the H1 Visa group. And then they were telling that she has to reach out to me. So she reached out to me, and then we were discussing back and forth of what events that we can do. And then she mentioned that one of the common questions and misunderstood aspects of the US immigration is the visa holders who are working do not have a good understanding of the employee rights. What is that you can do, what you cannot do. And because of that lack of understanding, employers take advantage of the employees at times. So we are going to be talking about that today. Hello, Dhenu, welcome to the program.
Thank you, Raghu. And thank you for the warm welcome. I'm really excited to talk to all of the viewers today. And I'm excited because I have some really good nuggets to share.
Awesome. So tell me about your practice. Where are you from? And your law firm. What is your specialty? And how long you've been practicing?
Sure. So I've been practicing 12 or more years, and in my own practice since about 11 years. The thing with my law practice is that we serve, majority of the people that we serve are either employees, small businesses in the business immigration side, or family immigration as well. And so most of our practice is actually transactional. And one of the reasons that I actually opened my practice, Raghu, was because I saw that there was a need for some advocacy on the employees front. I saw that there were a lot of employer-focused attorneys who practice immigration law, and they were focused on sort of, seeking out to employers. And then there was a gap, and the gap was that, South Asians in particular, who are employees, who are on these extended journeys, especially if you look at India, you're going to be on H1b for, tremendous amounts of years. And there's no one speaking on their behalf. In fact, most of the people said, when we contact the employers and we contact the attorneys, they say, oh, no, I can't speak to you, speak to the attorney that your employer has hired. But then when they contact the employer's attorney, they don't want to speak to them either. So who do you go to? And so that was my inspiration and my motivation for saying, you know what, something needs to change. There has to be someone who is speaking on behalf of these thousands and thousands of people who are on H1B. And, there's no voice. I mean, there's really little power in the system. So my hope is that, maximizing the little power that H1B does provide the employees would be useful in trying to navigate this really complicated and sometimes very lengthy process.
Sure. And you said a very important point there, because F1 students are in school for 2 years, 4 years, or whatever degree they're doing. Then they get employed, they start working. Yep. Until their H1B is filed, they do not have any contact with an attorney. Right. So it is just the employer and the employee, and maybe they are talking to the DSO. But right. If they have any status issues, their primary source of information is Facebook groups and their friend circle, yes, which are not always an authentic source of information, and it can be misled, because in the F1 group, I can see there are so many questions that should be answered by an attorney, but people are discussing, and there are so much of misinformation about others are sharing it. So they do not, their understanding of the law is whatever they have went through, and they never dealt with an attorney. So until you have a representation in terms of an employer, you really do not have somebody where you can go and talk to. So there is a gap for F1 and OPT, STEM OPT. Then even within the H1B framework, the employers are paid by the attorneys are paid by the employer. They do not represent you, they represent your employer and their best interest. So, which means either you have to talk to your HR, and HR will talk to the attorney, and then you get the feedback in that loop. Sometimes you cannot talk to the attorney directly. That is how it's set up. So that is why, and within this framework, And there is consulting companies where they have to sign, employees sign contracts, and there is non-compete agreement. We have seen so many cases where they start working directly with the client, and there is employer sending them, hey, you have to pay me $20,000 because you broke the contract. So there is all those things. So we want to talk about that today, right? So let's talk about what is an employee right in general. What do you mean by that?
Great question. And so basically, when I say employee rights, there are some rights that are provided in the law, right? For what the employer has to give the employee in terms of documents, for what information the employee has to have. And then I'm also, Raghu, I also want to talk about strategies, because, you know, rights is something that is in the law, but what about strategies that you can use in practical settings to actually gain access to those rights? Sometimes it's really, you know, you find rights, you know, listed somewhere and you're like, yeah, these rights are good. But then what if I try to use one of these rights, or what if I try to claim these rights and then they fire me? And then what good do these rights even do for me, right? So I really want to talk about not just rights, because rights you can find, you know, in different groups and different places. Yes, rights too, because you have to know them, but also strategies, because that's where you can really understand in practical settings, how do you take advantage of these rights?
Okay, so let's talk about the first thing. Let me open up the questionnaire. Let's talk about what are some of the rights that an employee has. Let's start from there, and then we'll go into the strategy.
Sure. I'm going to go through a long list of rights, actually. And if some of your viewers want to take notes, this is a great time to do it. And then we'll talk about, you know, a little bit more in depth of how you can actually gain access to these rights in practical ways. Okay. So I have these written down, and so please pay attention. These are kind of extensive, I'll warn you, but they're very, very important. So the first right is that you have to have a copy of your LCA. Okay, the employer has to provide you a copy of your LCA. This is really important. I have had clients who have said when they're entering the United States for the first time, they've been stopped by immigration officials and they're said, where's your LCA? Okay, and they don't have one, and that has been a reason for them to be put into secondary inspection, questioned further. Sometimes they call the employer, and then the other thing is that sometimes, you know, the LCA is incorrectly filed, and it's filed for a different project, and they're entering from a different port of entry. So all of these problems could be avoided if you actually request a copy of your LCA, which you should be provided, and you have to be provided by law. So that is one of the important rights. The other important rights is that if somebody has their H1b approved, there's two approval notices that usually go out. One goes out to the employer, one goes out to the attorney. Okay, the employer's approval notice, which is I-797A, has a second portion on the bottom, which is I-797B. That portion is meant to be provided to the employee. So you have the right to request that. That will contain your receipt number. It will also allow you to track your case if there has been some additional activity on it. It will allow you to even change employers at some point down the line. I've heard so many stories about people saying, oh, I can't change my employer because my employer will not provide me a copy of the approval notice. Well, they should have provided to you the minute you got it. So you don't have to request it when you later down the line want to change your employer, you know?
Okay. So even if they don't get the full I-797A or A form, then at least they should give you the I-94 arrival departure record.
Exactly. That's right. That's in the bottom portion of that. And that has the I-94. They have to give you that. Okay. The other thing is you, as an employee, do have to be paid the same as US citizen or permanent resident employees. So you shouldn't be on a lower salary level just because you're on an H1B or, you know, you shouldn't be put on bench. This is a common problem we see with some of the smaller consulting firms. The smaller consulting firms, they say, oh, you know, we don't have a project for you, so right now you're on bench. They don't pay you in the time that you're on bench. But what they should be doing, and what you can enforce as well, and we'll talk about enforcement later, but what they should be doing is that they should be actually paying you even for the time that they don't have a project for you. And they can give you work to do in that time. They can give you work to train. They can give you trainings to do. They can give you work in-house to do in that time, but they do have to continue. And this is, again, the LCA specifies what salary you should be paid. So they can use that. You can use that also to enforce it. You should be a W-2 employee, not an independent contractor. This is a common one. I don't think a lot of people actually miss this, but this is just one of those rights that you have to know. Your pay, this is one that I see a lot of people complaining about. Your pay cannot be contingent on the employer receiving their pay. Okay, so people, what clients come to me and say, they say, well, they're delaying my paycheck because they haven't gotten paid yet. That is not in line with the agreement. Your pay has to be continuous. It's not contingent on them receiving pay from the client, right? Yeah. Exactly. And one of the reasons this is really important is that the employer, when they filed your H1B application, they provided proof that they have sufficient sources of funding outside of just that client. So yes, primarily they're, most models, they're paying you a cut from what they receive from the client in this consulting format, right? But they have provided evidence that they have other sources of funding as well for in those rare situations where, if the client has delayed their payment, or if you're without a project. So they should be paying you using these alternate source of funding, but they should not, your pay is not contingent on the employer receiving their portion of the pay. Your benefits package should be the same as any other US employees. This is pretty straightforward, so we'll just move on. The employer cannot ask for reimbursement for the government fees that are paid on behalf of your H1B application. Now, there are, and this is where people get mixed messages about attorney fees, okay? Can you as an employee pay attorney fees? In some situations you can. This is a case-by-case situation. You have to ask, talk to the attorney about when you are allowed to, as an employee, pay attorney fees, but it's not recommended. Okay, it's not recommended. Some people will say you cannot, but if you read the letter of the law, it actually says you can pay, not that you can pay, but you should not pay the attorney fees if paying the attorney fees will make your total salary go below the prevailing wage. Okay, so if you're being paid significantly above the prevailing wage, and paying the attorney fees will not dip your level below the prevailing wage, there's some possibility for this. So this is, again, you want to talk to an attorney about this, but this is essentially what it is. But you should never be asked to pay the government fee, and it should never be asked as a reimbursement either.
So when you say government fees, so there is a fraud fees and there is an application fee, right? So those are no.
Also the acquia fee. So those are no. Yeah.
Okay, 3 fees.
Yes.
Okay.
Yes, right. And if they're like an H1B dependent employer, then there might be more fees. Okay. Those are no-nos. Now they can ask the employee to pay the premium processing fee. That is allowed.
Okay.
So that's what and these are very strict. So if the employer is found to have sought reimbursement from the employee for the fees where they shouldn't seek reimbursement for, then it can really be a problem for the employer, and they can be fined pretty heavily. So you want to be careful. Even the employer should be careful actually on this front. Okay. Your working conditions. Your working conditions should be the same as US employees. So you shouldn't be asked, just because you're on H1B, you shouldn't have to work, an extra 15 hours where everyone else doesn't have to, right? So because your working conditions are supposed to be the same. If in case an H1B employee is terminated, they do have to pay, the employer has to pay for the return transportation, okay? And this is really important because, this is something that a lot of my employees fear is, what if the employer sues me? What if they retaliate? Well, by law, you should not have to worry about that, because the employer cannot retaliate, because you're just enforcing your rights. You're not doing anything illegal, you're enforcing rights that you already have, and the employer cannot retaliate for that. And we'll talk about how to enforce those rights a little bit later. And you have, this is really, really important, you have the right to be informed. Okay, so so as an attorney, I'll talk to you some of the trainings that we receive when we do learn, continuing legal education classes and stuff on business immigration. They always tell us, remember, you're representing both parties. You're representing the employer and the employee. So we're always learning that we are representing, when we represent someone for an H1B, we are representing the employer, but also the employee to a degree, right? So what degree is that? Well, the employee does have the right to be informed about the status of their H1B application or their green card application or any of those employment-based applications. So when people say, well, I don't know if they actually applied for this or if they did file the application on time or if they did respond to the RFE, that's, you should know that. And how do you actually enforce those rights? That we'll talk about later, but you have to know the status of your application because you have the right to be informed. And, I want to touch on OPT a little bit as well, because that's many people are on OPT before they get on H1B, right? And I think many of our viewers are also on OPT. So OPT stands for Optional Practical Training. The key word is training, okay? And so what that means is that you should have the opportunity to use this time to learn. This is not, you shouldn't be in a OPT setting where no one is supervising your work and you're just independently, fulfilling a function, because that will also get you in trouble later on if, you get RFEs and stuff. But the key thing is that there should be some level of supervision, at least some level of supervision, right? Or if you're getting like webinar trainings or something like that, there should be an ongoing process for training, because OPT, CPT, both of them are training. Okay. So those are the, in general, those are the main rights that H1B and OPT holders should be mindful of.
All right. And for readers who are listening to us on Zoom, you will have plenty of opportunity to ask questions, and you will please use the Q&A option you will see on your Zoom screen to type in a question. Please do not use the chat window to post your question, because it's very hard to manage that. And also on top of it, people who are here on Zoom, you can request to speak. There is an option to raise your hand. So if you do that, then I'll also give you permission so that you'll be able to speak to the attorney through your microphone. So we'll get to that in a bit, but I just want to let you know. Okay, and those who are listening on the Facebook Live, you can post it on the comments part of the Facebook Live feed. So when we get to the Q&A, I'll go through those questions and then pick up a few questions to ask to you. Okay, all right, so let's continue, Attorney.
Okay, so one of the other things that I want to talk about is that H1B holders always ask me, can I invest in something or the other? Can I, what if I want to start my own business? And these are really interesting and complicated topics, but I want to touch on them because I think there are some portions that, viewers may not even know that they should ask about these, right? So one of these is that, yes, you can part-time study while you're on H1B. You don't need to get on an F1 visa for that. You can also invest in like real estate. You can invest in stock market. You shouldn't be doing day trading because that's considered more like your work. It's for income, not investing. But yes, if you want to, invest your money, of course you can. Okay. Now this is where people don't really realize. So you have the right to request a second H1B simultaneously, right? So sometimes people say, well, such and such employer may only have 30 hours of work for me and they don't want to sponsor me because they don't have the funds to do a full-time H1B. Well, keep in mind in the LCA, they can go by the hourly prevailing wage. They don't have to go by the yearly prevailing wage. So if they are able to pay you the prevailing wage on the hourly basis, you can have two employers. You can have one that maybe does, 30 hours, and then you can have a second H1B that does maybe 15 hours, you're perfectly within your rights to have two simultaneous H1Bs. You shouldn't be working for another employer without a second H1B.
So
right?
can a person have a full-time 40-hour paid annually and have a 10-hour part-time paid hourly?
Yeah. And you know what's more interesting is that people, especially who have that entrepreneurial spirit, if you want to work on your business on the side, you can even have your own business sponsor that part-time 10-hour H1B, but you shouldn't be working on it without the sponsorship of an H1B. So that's something you should, at least, if this is a topic where you're interested in, it's very complex. It's more complex than I can go over in a webinar like this.
We can probably do another session just on part-time concurrent employment or business interest session. Okay.
Yeah. So these are really good. And then, you know what, another thing, Raghu, is that if people talk about oftentimes, cap exempt and cap subject, and lottery has become a really big thing. So if you have a cap exempt H1B for one of those, and then you can get the second one as a cap subject H1B without having to go through the lottery. So those are some really interesting
do not know that. That is something really interesting. And people ask me so many times that, hey, I got an H1B on an university IT job. How do I come to a regular cap-based one? So they can use this. It is just that they are not aware of it.
Yeah, exactly. So these are some things that I noticed that a lot of people miss out these opportunities because they're just not aware. And, with the lottery numbers being as tight and difficult as they are, these are really important strategies. So that's important. And then, I want to talk about, Raghu, the enforcement portion, because I get clients, they're so afraid. And this is partly cultural, right? You tell me if it's not. We're taught to respect authority. We're taught employer, sir, madam, we're taught to respect authority. So we feel shy to enforce our rights, or we feel scared. And, we think, okay, if I try to enforce my rights, does that mean that they're going to fire me? Does that mean I'm burning bridges? Does that mean that I'm, going to lose my status forever? Right? These are 100%. Some fears.
I agree with you 100%. And it applies to anybody who is coming from India, because that is our culture and we tend to follow and apply the same thing here, but that's not the case. At the moment you see how your co-workers who are green card holders or citizens talk to your manager, you will get to know, you don't have to tell in a way that, sir or ma'am, hey, we are equal. Manager or be it, okay, you respect for their position, but you not have to be behaving like, yes, sir, I will do whatever you want me to do. Friday evening, 5 o'clock, you give me work, I will still do it. That is
exactly. Exactly. So this is important because actually the key here in our American work culture is that the law is the underlying current, right? And this is really important because it's an equalizer, right? Employers have to follow the law, employees have to follow the law. So the law equalizes your power, and you have to learn how to use it, not be afraid of it, right? So how can you enforce your rights? What happens if the employer is underpaying you? You know that the employer is underpaying you. They're using you for too many hours. You know that they're not paying you. They're not providing you pay stubs. They're not providing you notices from the H1B that you should have in order to be able to change your job. Well, it's interesting because if you look at American history, there's a lot about our history in connection with, we fought against slavery. We fought for these freedoms, right? It's a very hard fight. And so in the Constitution, anything that is kind of considered as forced employment, that it touches upon those same kind of themes of like being forced to work somewhere, it's sort of like slavery, right? And that's absolutely, absolutely not acceptable. It's protected in so many ways. And so if the employer is not giving you the right documents, that's like they're forcing you to work someplace, even if they're paying you. You shouldn't be ever in the position where you're forced to work someplace, right?
How do you get the documents from them when somebody tells that, hey, I cannot give you an I-797 or labor? So how do you get it from them?
you have to file a Department of Labor complaint. Okay, now people are super scared when they hear about Department of Labor complaint. They think, oh my God, I'm going to be burning so many bridges. I'm probably going to lose my status. You know, this is really scary, but it's not. Okay, in reality, it's a very simple process. So you go to the Department of Labor here in Chicago. It's like a walk-in office. I think most places it is. You go in there. There's a short, simple form that they ask you, you know, they even assist you in filling out, like what are the violations that your employer has committed, right? So you fill it out. And in some cases, believe me, Raghu, there's like literally no downside. Like, for example, if an employee has been laid off and the employer isn't even sharing their pay stubs or not paying them, okay? And so they've spoken up and then they've been laid off as a result, right? So now they're really scared because, you know, 60 days or they'll have to leave, right? So it's a very scary time. And so this is the time. What do you have to lose? You've already been laid off. You've already lost that position with that employer, right? You go and file that DOL complaint. If anything else, the employer will be notified and it will give them the incentive to provide you the documents, the pay, whatever has been withheld from you, right? So you can go and move on to the next employer safely without having to have gaps in your status, without having to have problems. And keep in mind, remember I said they cannot retaliate. So if any action they take to retaliate, just because you only sought to enforce your rights, if they're trying to retaliate, that's like a huge violation. So if they consult with their own employer attorneys and they say, look, you know, this employee has filed a Department of Labor complaint against me, and now I want to blacklist them and I want to, you know, badmouth them in the whole industry or retaliate in some way, their employment attorney is going to say, don't do that. Don't do that unless you want to lose the ability to operate, you know, in the state, and it's very serious consequences for that. So they're not allowed to retaliate. Okay, so that's one thing. The second thing is risks if you file DOL complaint. Think about it this way. So say if I lost my passport and I want to get a new passport, right? The first thing that most people are recommended is file a police complaint for a lost passport. Why? Because that way you can get a new passport. Now, do I care if the police actually finds the person who stole my passport or whatever? No, I just filed a police complaint because that's how I can prove that I'm not seeking to do some kind of fraud by getting two passports, right? That's how I can prove that I am the victim, not the perpetrator. Right? So the DOL complaint works like that. It actually protects the employee, right? So if your employer, and there are some really, really shady employers out there. So if your employer is one of those people who's just left and right violating rules, right? And you are one of the victims of that, and you file a DOL complaint, then what that actually does is it protects you, because if that employer is audited in the future, you're going to be suspected of collaborating with the employer in those violations. So you want to protect yourself and wash your hands clean of any of those violations. The way to do it is to file a DOL complaint, because that shows that you're the victim and you are not the assistant in those, you know, the co-conspirator in those violations.
Makes sense. That is something new, right? Basically, you're telling, hey, I'm not part of this, so I am taking whatever the steps I can do, continue to keep my job, so I'm filing a DOL complaint.
Right. And
okay.
What happens is, and this has happened to people who have consulted with me before, what happens if the employer is audited for violations is that they suspect that maybe you knew and you cooperated with the employer, right? So, and if you say, no, I didn't, I was the victim, then the very next question is, well, if you were the victim, then why didn't you complain? Why didn't you?
Okay. So
right?
If you had a complaint filed, then you can say, hey, here is the steps I took. Okay.
Yeah. So this is a proof that I didn't do it. You know, this is your protection. And it's not just people think, oh, I don't care about, you know, punishing the employer. It's not about punishing the employer. It's about protecting yourself and clearing your name from any of those violations.
Okay. All right. That's what else do you have? We have
and then-
questions. Do you want to go to questions or?
Yeah, let's take some questions based on what we've talked about so far, because I think the next thing I want to talk about is practical strategies. But
Sure.
yeah.
All right. So let's answer a few questions and then we'll go to the strategies.
Sure.
So I got a question here. Does these rights vary from state to state?
No. So that is a very good question. So there's some rights that vary from state to state. Those are like the employer laws, like employment laws, rights vary from state to state, but immigration rights are consistent in the entire country because it's a federal area of law. Okay.
All right. And can you speak up?
Hi, can you hear me?
Yes, Srikanth, go
Yes.
on. What question do you have?
Good afternoon, Dhenu. Hi, Raghu. Thanks for the opportunity. So, you see, I mean, I'm basically with one of the employer. So I'm working in EVC model. So basically what happens whenever many of my friends or many of my colleagues who I know, most of them, whatever we do is like we talk orally with the employer when we join at a specific employer. So the conversation goes in the day one and they agree to a certain pay, but they change their words in translation after 6 months or probably down the line or once they get the job. So how can take this forward when we have this discussion orally? Because it's truly happened to me. If you talk about my case, I've done a project for like a short term, like which is for 2 months, and they started coming back to me and they're showing some reasons based on some performance, and they are saying that no, this is the percentage we can't pay, and we are going to decrease your pay based on your performance. If performance is only the criteria, then they didn't do anything for me to improve my performance. But all this was a oral discussion which happened over the phone through HR. But
okay,
always lose her words in translation, and she routes my questions to the VP of the employer, and how I can take forward in terms of this percentage.
All right, thanks, Srikanth. Attorney, handle this.
Yeah, sure. So, I mean, this actually goes to a strategy, actually. And one of the strategies that you can always use, because I know that sometimes employers are very cautious and they purposely have these conversations orally instead of in writing. So what you can do as a strategy is after every conversation, key conversation that you have with the employer, always send them an email summarizing the main points discussed and say, please let me know if my understanding is inaccurate. And so they have the opportunity then to respond to you if they think that you've missed some point. But if they don't respond to you, then that itself is a proof that you had asked to clarify and you had asked them if your understanding is incorrect, that they should respond to you, and they didn't. So that is proof that you can present to say that they violated their own terms of employment. Now, this goes a little bit into employment law, right? Because when you agree on certain terms, that forms a contract. A contract is nothing but an agreement. It can be an oral agreement, a written agreement, any kind of an agreement. So when they violated contract, that is a contract violation. Now, but if their pay is actually below the LCA pay, then that goes into an immigration violation. And so that's something that you can report then to the Department of Labor and say, look, they filed paperwork that says that they're going to pay me a certain amount and they're paying me below that certain amount. So that is an immigration violation then. So all I was saying is, that you want to separate the issues a little bit just into immigration and contract violations. There's some contract issues when an employer does that, right? Like when they just without warning pay you lesser. And that's something you can explore, and that's more state law, contract employment attorney conversation. But as an immigration attorney, I can say that most of the time when the employer says, oh, performance issues, I'm going to reduce your pay. Well, most of the time they're going below the wage level that they've reported on the LCA. And then that's an immigration violation. So you having the copy of the LCA from the very beginning protects you in a lot of ways down the line.
Okay.
All right.
So basically, I'm on OPT. So the thing is that there is no, LCA kind of thing. But
Okay.
this is
Right.
what we have done. I mean, that's a good. I mean, it makes really sense. Like, I need to send a follow-up email to them. Like, what I was
Yes, that's a
because
great strategy because that will
yeah,
protect you in so many ways.
because they have charged H1b amount also from me. I mean, now after 1 year, they are coming back and they are telling that we are going to reduce this amount, the attorney fees, this, that. I mean, they are telling all the reasons, and they are going to give me only some part of the amount which I paid.
Yeah. I mean, consider changing an employer like that, right? But if you can't, in the meantime, every conversation you have with them, always send a summary in writing.
Okay, makes sense. Thank you so much.
Sure.
All right. So Dhenu, please continue with your next steps.
Yeah. So these are really exciting steps that I think people will benefit from tremendously because they're strategies, right? So a lot of times you know these laws and these rules, but you don't know how to apply them in your own situation because there is, like we talked, Raghu, that feeling that you're powerless in the situation, which is not true, right? But you have to understand the dynamics of power in order to apply the right strategies. When does an employee have the most power in this whole employment process? When they have an offer in hand and they're deciding whether to accept it, right? That is when you have the most power, because at this point, the employer has said that they want you. Probably they have seen things in you that they haven't found in other applicants, right? So they want you. Now they're hoping you accept the offer. Most of the times employees will use this opportunity to negotiate salaries, bonuses, other things, right? What about your immigration? One of the things you can negotiate in this time, and it's so important to do it, is choosing your own immigration attorney for filing your H1B.
Is that something negotiate?
Yeah, so many of my employees do. When they're at that position, they say, okay, you know what? The employer is offering me this salary, this benefits package. This is wonderful. So one of the points they counter with is say, well, I would also like for you to pay for an immigration attorney that I choose.
That's awesome.
Now, this is really huge, right? Because you're going to choose an immigration attorney based on someone who's going to do the best work for you, right? And they're going to choose an immigration attorney based on completely different factors. They're not concerned about, your immigration history to the same degree and your immigration future to the same degree as you are. So this is really important. And the other thing that most people don't realize is that, remember how I said that immigration attorneys actually have responsibility to both parties to a degree? Well, when it's the employee who initiates the communication and the contracting with the immigration attorney, even though this is an employer's application, and even though it is the employer paying for this application, because it was the employee who found the immigration attorney is going to be a little bit more responsive to you. The immigration attorney is going to give you more access, is going to give you more of an opportunity to discuss your issues regarding your immigration history, your immigration goals, right? So you choosing the immigration attorney is the #1 power move that you can make in this process.
All right. And of course, the next question that you're going to get from people who just listen to that is, what if I withdraw my offer? Will they have the power to either deny it, or what if they say, you know what, we can't give you that and we're going to retract the offer?
Sure. I mean, look, almost no one's going to actually withdraw the offer in reality, right? Because all they can do is they can say, no, we can't accept that term. Right? We can't give you the opportunity to choose your attorney, maybe because they have a contract with another attorney, maybe because they're scared of whatever, right? So they may say no. That's fine. They can say no, right? If they say no, what are some other strategies you can do? You can negotiate access right to the company attorney. You can say, okay, well, if you're not going to allow me to choose the attorney, can you guarantee that I will consult with the attorney you choose before we begin the H1B process. And you can have that one-on-one consultation and the employer can agree to that in the beginning. Now, what happens if you don't mention this at this time? Probably the employer is going to be like, no, you just go through my HR for everything, right? But when you're in this process, they might say, okay, well, who's going to really turn down somebody because they want a consultation with the attorney?
Sure.
Right?
All right.
So that's the plan B, right? Like you can, if you can't make that number one power move that I said, which I think everyone should attempt, by the way, because almost no one I know has lost a job over it. People, the most the employer has done is say no, right?
Okay.
And the third is, negotiating access to the company attorney. And then the third thing is, having, this is Shrikant, I think, asked this, having everything in writing and having copies of everything that, is given to you in immigration in real time. Like as soon as you get the RFA, request a copy. Don't request things when you're looking to switch attorneys switch companies. Request things on the go, right? And follow up in writing with every communication that's important that goes on. And then here's one more thing you should keep in terms of documents are redacted copies of your work product, because immigration is getting way, way, way more restrictive now. And if there's and this is great for OPT holders too, by the way, because like I said, OPT is training. And if later on, when you're trying to change your status to H1B, they say, well, give us, proof that you were in valid OPT status, give us proof of that. And, you are maybe not on great terms with the OPT company. Maybe they're scared for their own reasons. Who knows? They're going to say, no, we can't give you, access to that account anymore. We can't give you access to those trainings anymore. But if along the way, you've kept copies of the work that you produced, that's proof about what you were involved in, proof of the field you were working in, proof of the work that you did. Of course, if there's any sensitive data, you can black that out. You don't have to give them sensitive information. You can black that out and still present your work product. And if you're being given trainings and things like that under OPT, keep copies of those trainings, maybe those emails, things like that, so you can prove that you were in valid OPT status.
Awesome. All right. So, Attorney, let's answer one more question. Go on.
Being an H1B, is day trading of stock in H1B completely unacceptable, or we can do some transaction, let's say once or twice in a week?
Oh, day trading is different from like an occasional transaction once or twice a week. So when I say day trading, I mean that your active source of income is only like mainly from trading, right? If you're trading once or twice a week, that's different. Day traders sometimes trade multiple times in a day because their whole source of income, main source of income is coming from trading. So you can't do that and also be a full-time employee at another place realistically. So that's why they say, well, day trading is more like work and less like investing, right? But if you're investing and you're trading occasionally, that's different.
Yeah, and I think my question is basically, if you do day trading once or twice in a week, the stock exchange. So
I mean, there's no hard and fast rule. These are case by case determination, right? Like when does it go from investing to trading to like almost work, right? It's something that I think you have to kind of evaluate on a holistic way. Like if you're actively trading stocks to the point where you can't focus on actually working, then that's a clear sign that it's work that you're doing and not investing. But if you occasionally trade, like, okay, this COVID thing is going to really ruin your portfolio, and you decide, you know what, I'm going to sell some stocks, I'm going to buy some different stocks. I mean, I wish I'd bought Zoom, so then it's different, right? You have to evaluate it from a holistic perspective. Like when is it going from investing to actually impacting your work? So then it's more likely to be considered work, which you're not allowed to do, versus investing, which you are allowed to do.
Okay, yeah, I got you. Thank you so much.
Yeah.
All right. All right. So what's the next strategy?
So those are the actual strategies that I have that I think people have not previously heard of before. And, you know, I've found, Raghu, that when people realize, oh, yeah, there's one more, which is, you know, people say, well, you know, this is hard because I have to rely on the same attorney that the employer is using for the H1B. And maybe they're not being as communicative as they should be in reality. Well, then what can you do? And when can you hire your own attorney as a secondary source of representation? You always have the right to having your attorney represent you in your portion of the immigration, like not in the H1B filing, but say if you got an RFE and the employer is requesting you to provide certain documents, and you're like, I hope these are the right documents. I hope these documents actually will help me overcome this RFE issue, right? You can always have a consultation with your own attorney to review your portion, your documents, your portion of the case, right? So that, you know, it doesn't impact the employer's attorney in any way. It doesn't impact the relationship you have with the employer. But at the same time, you can be a little bit more confident that you're using the best sources that you have in overcoming those issues.
Sure. In addition to that, there is another question that I often hear, which is, I am scared to go talk to an attorney because I'm thinking the attorney will go and tell to USCIS about things I have done.
Right.
And that especially comes from OPT folks because they never interacted with an attorney before, and they never had something called as, they never paid for a consulting. Yes.
Right.
So they are scared that an attorney will go and tell to USCIS. So how would you?
Yeah. This is exactly why, Raghu, anytime someone consults with me, I mean, like you can test me on this. I always begin my consultations with what we talk about today is confidential, right? Because that is a responsibility that an attorney always has to maintain your confidentiality whenever you're in an official consultation setting, or if you're in a representation agreement, they have to maintain your confidentiality unless it's a dual representation, right? Like in the H1B setting, if you tell your employer's attorney, hey, you know, I'm thinking about leaving this firm, they're probably going to let your employer know. So don't do that. But if you're seeking, you know, advice as an OPT holder, like you mentioned, it's a really good thing to do, by the way, to seek advice. You won't believe how many people I have who every couple of years will just schedule a consultation just to help steer their immigration goals, right? And I have never represented them on an H1B case or any other case sometimes, but they still value that advice that is unadulterated, which is different from the employer's attorney and the advice that they will give because their goals will be a little different. It's so important. And as an OPT, you have to remember that your entire immigration journey is in front of you, right? You've just begun. You're still a baby when it comes to immigration, right? And so you have no idea.
You're just learning to walk. You're going to fall down.
You're going to fall. Like, okay, you have no idea yet. Okay, you have no idea, right? I mean, you tell me. There's so many things. There's so many things that will potentially come and impact your immigration journey. The best investment you can make in yourself is to have good advice. So it's one of the best investments.
The way in which I always tell the same thing, and I have so many of Happy Schools readers who just come and talk to me once a year. I'm finishing my master's. How are things looking like for me? So it is like physical every year, right? You're getting your physical done with your doctor, but F1 students are probably not doing any physicals because they have the concept of that is not there. But once you get into H1B, then you start you have better insurance to do it. Same thing, just getting, what do you say, your in navigation terms, right? I'm trying to find the right word.
The steering your
steering, So making sure you are in the right direction. And one other common thing is employees start working, they get their H1B, and until then they are like, you know what, I'm giving pressure to my employer. Hey, I want H1B, please apply. The moment they got H1B, they take their foot off the gas. Next time they remember they want to talk to their employer is when the 3-year extension is coming to end, or the 6th year H1B is coming to end. That's when somebody will tell them that, hey, you cannot continue to be on H1B beyond 6 years. You have to have started your green card process. Even 2 days back, there was a question. A person commented that why even bother applying for a green card when the wait time is 60, 70 years? So I tell, after 6 years, what are you going to do?
Yeah. And you know how many people I've spoken to, and I've said, you know what, you actually would have qualified for an EB1 even. Like, you just needed the right guidance. And you were like just little inches away from it. And they say, oh, if I'd known that 3 years ago, well, you should have been in regular communication with somebody to help guide you in those things, right? These are difficult processes. These are not things that anyone should just expect to learn on their own, right? So I mean,
that is exactly what I'm doing with my premium membership, is to bring in attorneys like you, or bring in somebody who has went through the process. I interviewed a person who is from Hyderabad, but he was born in Middle East when his parents were there. He forced his employer to apply for his green card the moment he started working for them.
Right.
So by the time he got the end of his OPT, he got his green card.
Yeah.
So the employer said no. His attorney said no. He didn't take no for an answer. He said, give me a law that tells me that I cannot file for my green card while I'm on OPT. He went and fought, and then he got his green card. So a lot of things are there. You just have to keep an eye out. Your social circle are the people that you are, or they are in the same phase of your life as you are. Most of the times, you are an OPT working for an employer. Your social circle is pretty much another person of the same kind. They do not have the information of how to plan this out for your career. So your knowledge is limited. So that's when you have to talk to somebody who has gone through this journey, so that you know where the pitfalls are and try to avoid it. And the strategies that you gave was really awesome.
I mean, you know, Raghu, when you first told me about what all is included in the premium membership, I'm like, oh my God, how can you include all of these benefits for such a low cost? So I think anyone, I mean, if anything else, like, you have to be a premium member. You have to take advantage of these resources, because this is amazing. This is amazing. This is at our fingertips now, because look at what technology has done.
Yeah. So now all the strategies, right, are negotiating. Whatever you told today, Dhenu, I'm pretty sure the people who are listening on live, majority of them have no idea. Just take one thing, starting the cap exempt job and then getting a cap based, just that alone can help 40,000-50,000 people who are thinking that 40,000-50,000 people who get H1Bs on cap exempt every year, that I'm stuck on this job.
Right.
Yep.
Right.
So, awesome.
And how many people who dream about starting their own business, who think that they can't, right? And they just spend years thinking that they can't.
Sure, makes sense. All right, so let's take one more question. Soham, one more try for you. Don't miss this.
Hello.
There you are. Go on, please.
Yeah. Thank you, Attorney and Raghu, for this session. It's very helpful. So, can employees terminate you on basis of visa? Like, for example, I am currently having visa issues. My OPT extension was denied. So currently I'm on no status. My employer has currently put me on unpaid suspension. But they mentioned that until and unless we know that you are looking for getting your visa back, some documentation, like for example, filing an MTR against the denial, and employer has also filed for an H1B change of status from my initial approved consular. So we won't terminate you. But in the law, in their policies, it was written that after a particular period of time, like after suppose a month or 2 months, if the employer is still not able to get the proper visa, they will talk with the manager, and the manager has to tell the HR that this employee is needed, and only then they will continue with the employee. So I just wanted to understand, is there any law as such?
So to clarify, Soham, your H1B was denied?
My H1B was approved last year on consular.
Okay.
I didn't get it stamped. My OPT extension was denied because they thought my H1B started last year. It was not a change of status H1B. It was an H1B, which was not stamped.
Right.
So they have applied for a H1B change of status on the previous consular H1B right now, so that I can stay in the US. I have also separately applied for an MTR against the denial that I received.
Okay.
The two things I have done. But I am still on a suspension, so I don't know whether the employee can terminate me or not.
They can always, unfortunately, they can always terminate you, right? So that's the one power that the employer has in a recourse of these, as long as it's for a lawful reason, right? Like they shouldn't terminate you for an unlawful reason. And examples of those would be like because of your race, because of your pregnancy status, those are unlawful reasons. But lawful reasons include like things like your immigration status. So if you have an immigration status concern, the employer can terminate you. But here's what I think you should do in this situation. I think you should actually have an outside attorney review the denial, the reasons for the denial, and the filings that you've done to get a realistic idea of what is the chance of acceptance or approval for these filings. So you know that if in case, for example, sometimes it's not your credentials that are at problem, it's the employer who's problematic. So sometimes the best course of action would be looking for a less problematic employer. And the employer's attorney is not going to tell you, right? Like it's actually your best course of action is going to be finding a different job. But sometimes that's the best course of action because it's not something that you can fix, which is causing concerns. But it depends, right? Like depends on the strength of your filing. It depends on the specifics of the employer's sort of structure and things like that.
Okay. So I have already filed for an
MTR and
against that. So so that should be.
So they can terminate you, but I think here's where you use those strategies that I mentioned, like make sure you're following up with emails anytime you have a clear conversation with the employer, because some of those might go into contract issues, right? Like they might have a certain agreement with you. And then if they change the agreement, that might be a contract concern. Okay. So then you want to protect yourself by following up with them all the time with like, this is what we discussed.
Right.
Please let me know if this is not correct.
Yeah, this is not a contract-based thing, at least for, it's a full-time thing. But also another thing.
No, I don't mean contract job. Sorry, when I say contract, I mean any agreement you have with an employee in legal terms is called a contract.
Okay. Second question I had was you mentioned that usually employers are not allowed to pay or make you work more than the green card holders, right? But it is not usually direct, it is indirect basis on your performance. Like performance requirements, and an H1B or an OPT person who knows if he loses the job, he will have to leave the country if he doesn't get another job. So everyone knows that, and they have to actually work. Indirectly, it's kind of an indirect thing that happens.
True.
So, I mean,
true. And this is where you're right. Like there's some amount of leeway that the employer can get away with in terms of indirectly putting a little bit higher burden on the H1B. But you can, if you look at this in a more case by case, and this is where you really do probably benefit from, if this is a concern that you're seriously having, you should consult with an attorney, because you can determine based on a case by case scenario, like what is provable and what's not provable, right? Like sometimes you might think something cannot be proven, but if their requirements for you or their performance requirements for you are different from the performance requirements for a green card holder, that's something that can be proven, right? Like as long as you're, again, the best thing that you can do is you can follow up in writing everything so that you always have a track record in writing of everything that has been communicated to you regarding your performance requirements, regarding, sometimes, you might have to deliver results in a shorter period of time than other people get. And that's a performance requirement. That's a difference. And it requires you to work longer hours. And those things can be proven. So just always keep a record. And then you will, if you come to a point where you're like, this is too much, this has gotten to be, very frustrating, it's worth having that record reviewed and to see what can be proven in the form of a complaint and what cannot be.
Okay.
So awesome. What do you think about today's session?
Yeah, this was a very good and a very helpful session for sure. I think we need more such sessions. And also, as attorney mentioned, we can have another session with respect to having a second H1b, and that. So yeah, I mean, it is very, very, very helpful. Yeah.
And definitely for everyone who's listening, I know this session today is mostly focused on H1Bs and OPTs, but keep in mind there are other kinds of visas too. I mean, most of you will have heard of L visas, right? And sometimes those can be used very strategically as well. What about O visas? I hardly see our community taking advantage of O visas, which are a great, great, great tool. So those are some things that you can discuss when you actually take charge of your immigration process, right? You have to be the leader in your own immigration journey. You cannot let employers lead it. You cannot let your school lead it. You have to be in charge. And actually, for people who are on OPT, I have to say this. I'm shocked by how many of you don't know requirements for your OPT, requirements for your DSOs to follow. I mean, DSOs are wonderful. They're a wonderful, wonderful resource, but you shouldn't just assume that you will be fed information about your immigration process, because if something goes wrong and you say, oh, it was because the DSO didn't tell me, well, guess what? Too bad. You can't use that as an excuse.
Right.
If something goes wrong and you didn't follow the rules correctly, maybe you didn't get your employment in time, maybe you didn't submit your OPT in time, you cannot just say, well, the DSO didn't tell me.
And I think most of the students, as I know, I was also a student, they are unaware of all this, like whatever you're saying, right? I think what Raghu is doing is like, it's a very good initiative where more awareness is getting created. I came into this immigration because I lost my status. Before that, I was also not so, proactive on these things. But definitely it is very helpful.
Yeah.
All right. Thanks, Soham. Sagar, you are up next. What question do you got for us?
Yeah. Hi, Raghu. Hi, Dhenu.
Hi.
Yeah, I'm just wondering that is there any possibility to ask my employer to file a green card while I'm on OPT?
That's a good question, and I know Raghu has done.
So is there really a possibility that I can see?
Yeah. So I know, Raghu, you've done a lot of sessions and different kind of informational bits on green card from F1, and it is possible, right? But you're looking at moving from a non-immigrant status that has a non-immigrant intention requirement to an immigrant intent, and so it's absolutely it's possible. But at the same time, I think it's important to kind of work with somebody to closely monitor to make sure you're not risking anything in regards to your H1B. But yeah, it's 100% it's possible.
But the thing is, like, I'm still on my STEM OPT extension right now. It's
Sure.
just so I heard that there is another possibility that I can open a new like entrepreneurship, like I can start my own business on OPT, and can I file the green card on my own business? Is there
You
any
can,
kind of...
but keep in mind, green card has a requirement for you to have to advertise your position if you're doing it through EB2 or EB3. So you have to find, and this is where you have to work with a very, very experienced attorney to do. And we've done these, okay? So they're doable. But you have to understand that you're going to be advertising your own position to other people, and you have to prove to the government that that's somehow unbiased.
Okay.
Okay, yeah, that will be a bit of a challenge, but it's possible. As the attorney mentioned, I have seen how attorneys have done it. But so as she mentioned, right, there is not a one-size-fits-all strategy. If you're a one person or a 2 person, or do you have an investor, or do you have a board of directors?
Exactly.
All those comes into the picture. It is.
And you know what? If people, Raghu, if people are on their, say, initial OPT and they're in a STEM position and they have the possibility of doing STEM for a couple extra years, you can start strategizing now so that you have 3 years to develop your business in such a way that you can file for your green card, right? So that's exactly why you have to be in charge of your immigration process. You cannot just rely on the system to take care of you.
Yes. Sagar, what do you think about today's session?
It's really wonderful and great. I'm getting so much of information from you and Dhenu actually, and I'm happy in the happy schools.
All right. Yeah. So I've seen you on the previous other calls as well. So that's why I asked for your feedback, Sagar. Thanks a lot, man.
Yeah. Thank you so much.
Anima, your question.
So I have a question. It is actually, I'm going through through this, and with my previous employer, they made me sign the contract, and that if I left them before 1 year, I'll have to pay them 30K. And I'm still with I changed the employer after 7 months because they do not used to pay me on time and all sorts of things. So, but then I'm working with the same client. So it's been 4 months I left them, but they are still chasing me. And I got the email from them last Monday saying that they are going to file a lawsuit against me because I'm still working for the same client and I haven't paid them 30K yet. So yeah, I'm in this situation right now. So how can
So did you document the violations that they have done? Like, did you document when they were late in paying, or when they maybe not?
No,
do you have a copy of the LCA?
Yeah, I never did that. I do have LCA from them.
Good.
And I spoke to my current employer, and whenever they sent me email about like follow-up for to receive the payment, like requesting the payment to pay them back the 30K. So when I contacted my current employer, they were like, just leave it, don't respond them. They are not going to do anything. You don't have to be scared or do anything. So that's what my current employer response was. So due to the lack of information, I haven't done anything against them.
Okay. So let me take this opportunity to talk about this, because Anima, the issue that you're facing is one that I hear a lot, right? Raghu, did you hear this as well previously?
None of them.
Yeah. So this is a common problem too. And so one of the first thing is that, can the employer request any amount as, damages, right? If you terminate too early. The answer is yes, they can request some amount as damages, but they have to, in court, if the employer does, for example, sue you in court, theoretically, right? Then they have to be able to prove that that is actually the amount of damages they suffered. So they can't just arbitrarily put in a number just to scare you, 100,000, because you terminated too soon, and they only suffered maybe 10,000 of damages or whatever, right? Their number has to be reasonable in terms of the circumstances, right? That's the first thing. The second thing is that this is where what Anima is saying is they themselves were not perfect, right? They were missing payments, delaying payments, probably had poor work conditions. So this is why I'm telling everyone here today, document. Don't wait until the problem starts to keep these records, right? Follow up with the employer. When you have the employer and you're calling the employer and saying, I still haven't received my pay. Don't call, first of all, email if you can. Right. Secondly, if they're the ones who are like, no, we're not going to respond by email, we're going to call you instead because they're scared, then you follow up with an email in the way that I mentioned. But you have to document their violations, because then this is the time when you can come back and say, look, I can file a DOL complaint. You violated all of these things. And, I understand that you're pursuing me for this. That's fine. But I'm going to file a DOL complaint because this is how I protect myself. Right. This is how I protect myself.
Yeah. So actually the case is they actually haven't paid me full 8 November, and I left them in January. I worked for
What are you waiting for, Anima? File a DOL complaint.
Yeah. So
they
my
cannot not pay you. That's slavery.
Yeah. So I actually don't know how much they haven't paid, because they just used to send me the pay stub, but then they never paid me. Like, they just pay me the random amount.
Yeah,
but
see,
I
this
haven't
sounds like
how much
they violated a number of things, right? So take a look at your LCA.
Yeah.
Yeah. Okay.
Anima, so as Attorney Dhenu was telling, right, you have to document it. The first paycheck that you did not get on time, send them an email. Do not call them. If they call you back, you send them another email that, hey, I'm just summarizing what we just spoke, and then send an email. Could you just confirm if my understanding is right? So in that way, you are creating a documentation trail.
So can I still send them the email saying that if you don't pay me the pending amount, I will file the file against them?
Sure. So maybe you should schedule a call with Attorney Dhenu and then clearly understand what you should do, because this is just information, right? We are telling you do this, but if you schedule a call with her, clearly here are the things that you have to do, and then go and execute it. In that way, at least you know how to do it and do it in the right way. How can they reach out to you, Dhenu?
Yeah, so great question. Look, those of you who are taking notes, my phone number is 312-854-7065. Raghu, you gave the web address. It's SwagatUSA.com. Reach out to us through our, through a phone call. You can also email us, support@SwagatUSA.com. So those are some ways for you to reach us. Also, I have a Facebook page. I know I'm trying to be more involved with Raghu, this group, but you can follow me on Facebook as well. And I'm going to be attempting to reach out to as many of you as possible when there are important information that I need to disseminate.
All right. Thanks, Anima.
Thank you.
Yeah, but this is a common problem, Raghu, that we see, and people fail to document until it becomes too late. So I hope that other listeners try to prevent this from getting this far and start documenting, right away.
Sure. There are also other questions. I think pretty much you answered them. Question from Neil. Hi, Raghu and Dhenu. Can employer bind an employee with a contract for 5 years? Can the employer penalize the employee with a huge fine of, say, $20,000 if the employee breaks the contract? So you just answered with Anima's question.
Yeah, hi. Can you hear me, guys?
Yes.
Yeah.
You had questions about investments, right?
Yeah. So just a quick. It might sound very silly, but yeah, it's important for us to know, like, what does it makes different in H1b from a citizen standpoint of view, So in what we should be investing and what we should not be investing, and where is that thin line, So just wanted to get your opinion in overall. So suppose, like, I was thinking of opening an high yield online saving account, IRA account, and buying a house, all those stuff, which I believe we can do. But where is that thin line where it draws, like, hey, this is not allowed since you are a non-resident or resident, something in that way.
Right. So look, I'm going to give you kind of general info. Can you hear me? I know my video might have gone out. Okay.
Yeah, you're good.
So in general, the big picture rule is, right, like, because I don't have time. I don't think we have time to go into like each and every form of investment, but I'll give you the big picture rule. The big picture rule is that you can invest in anything as long as it does not require you to be active in working it, right? So think about jobs. Is what you're doing, is there a job title for what you're doing? So I'll give you an example, right? People say, can I invest in real estate? And the answer is yes, you can invest in real estate. You can buy property, you can buy commercial property, you can be a landlord, you can buy your own house, whatever, right? But what if you're planning to invest in real estate to the extent that you're managing a whole lot of investment properties, and that's going to require you to essentially spend a number of hours in, finding renters, processing applications, showing properties, all of that, right? So you're doing the job of a property manager, you're doing the job of an agent, and those are job positions, right? You cannot be doing that. You have to hire a property manager. You have to hire an agent. But yes, can you put your money to use? Yeah. So The same thing with accounts that you open, right? Whether it's stock trading accounts, you can do things on your behalf to the extent that it does not require you as much of time that it starts to interfere with your job, right? Once it starts to interfere with your job, that's a good rule of thumb. That's a warning sign. Something you might be crossing the line there. Right. So if it's something that requires you to, maybe, you're opening a startup or something, and it requires you to talk to have a couple of investor meetings to try and seek investments, few meetings here and there, that's fine. But what if you're doing, full time, you're putting in so much time and so much energy and having all these business meetings, these presentations, this and that. At that point, you're no longer a passive investor. You're starting to become way too active. So that's the line in the sand that you want to be aware of. Okay.
All right. Thanks, Ranjit. Ranjit, you still there?
Yeah. Thank you so much. I believe Raghu, at some point of time in future, maybe we are talking a lot of immigration, but if we can conduct a small, I saw your past investment webinar. That was really great. Thank you so much for putting that much of effort. You guys are doing really good. But if you can just follow up with this type of another webinar, I will really appreciate that, because
Sure.
we have been stuck in H1 and we are looking forward to do some more investment stuff, but so many questions are there. So we'll appreciate that if we can conduct.
Yeah, and quick point I should bring up is that, if people are on F1 or H1, make sure you're filing your tax returns with the NR form. This has come up to me recently with this stimulus checks. Some people on F1 received their stimulus checks, and that's a huge problem because you shouldn't be, because you should have filed in the 1040 NR, and people use TurboTax or somehow filed in the regular 1040, and that's not correct. So if you've done that, you might have to get those amended.
All right. Thanks a lot, Ranjit.
Thank you.
Rahul, you there?
Hey, Raghu. Yeah.
All right. Tell me. So I read your comments, but I just wanted to bring you and have you tell it out.
Actually, Dhenu has already provided so much of information. Like, I didn't feel like asking a question, but in future, I was looking to have more these kind of sessions. Thanks to you to organize these kind of sessions. And this is like an out of box seminar. I would say, like, none of the seminars I have attended so far provided this kind of detailed information about the employee rights, which is the main thing, which is based on which all the visa industry in the United States works on. So thanks to you, thanks to Attorney Dhenu, and definitely keep organizing this kind of sessions. For a future reference, let us know like best ways to reach out to you. Thank you so much, guys.
All right. Thanks, Rahul.
Yeah, thank you.
So
good
I think thanks to Attorney Dhenu, Maru, right? Because we are talking about having sessions. You are the one who said, nobody talks about employee rights. Let's do a session on that. So that's how it came, because I did not think that we are going to have content to talk about for hour and a half. And then if we continue, we probably will go until end of today. So that's how many questions are there. So let's stop right here, because we have gone past more than 30 minutes than what I actually told Attorney. But very useful session, a lot more practical tips. And
sure, one quick request, Raghu. For those of you who are listening today, for my own sake and my feedback, would you rate me from 1 to 5? How important or informative was this session? And just put a comment in the chat box. I think, Raghu, that will give both of us an idea of like what the content we should provide should be. All right.
Sure. All right. So I'm getting 5-star, 5-star. And those who are also listening on Facebook group, please also post your comments in a scale of 1 to 5, 5 being the highest rating. So 5, 5, 5. It was a great session. 5, 5.
Wow, we're getting a lot of 5 stars. I mean, this tells us, Raghu, these are topics that I think people do want to and need to hear. What do you say we should do? Additional seminars similar to this, maybe focus on slightly different focal points.
Sure, we'll do that. It's 5 everywhere. I'm getting in Facebook group as well, 5 out of 5. Yes, it's very useful. Awesome. So we will, before we wrap up, how can they reach out to you? where can the members follow you? What is your email ID? What's your URL? One more time.
Yes, absolutely. So guys, 312-854-7065. That's my law firm phone number.
All right, sounds good. Awesome. Thank you, everyone. Thank you, Attorney Dhenu. Maru. She's based out in Chicago, Central Time Zone. So that is something we had to tell, because I've seen people call on Friday at 5 o'clock Pacific time and they say nobody's picking up the phone. So be careful about that. But yes, I'm sure we're going to have Attorney Dhenu Maru again in another session. All right. Thank you, everyone. Well, thanks for joining. Thanks a lot, Attorney.
Thanks a lot, Raghu, and thanks to everyone who watched today. I wish you all the best.